So now we'll be talking about Canon 2 of CPRA, and it's about propriety. Okay, so this will be a little bit lengthy, but it will discuss all those important topics under Canon 2 propriety provisions of the CPRA. Let's begin. So, a lawyer shall at all times act with propriety and maintain the appearance of propriety in personal and professional dealings, observe honesty, respect, and courtesy, and uphold the dignity of the legal profession, consistent with the highest standards of ethical behavior. So let's talk about proper conduct or dignified conduct in sections 1 and 2. So, immoral conduct states that immoral conduct is gross when it is so corrupt as to constitute a criminal act, or so unprincipled as to be reprehensible to a high degree, or when committed under such scandalous or revolting circumstances as to shock the community's sense of decency. And these distinctions are made as the supreme penalty of disbarment arising from the conduct requires grossly immoral, not not simply immoral conduct. So what is required for you to be for a lawyer to be disbarred is that there must be gross immorality or grossly immoral conduct. So kapag simply immoral lang or just being immoral itself, di siya pwedeng categorize as automatically or automatic ground for disbarment. So number three, employment of disrespectful, abusive, and abrasive language serves no useful purpose and on the contrary constitutes direct contempt or contempt in fascia cray or fascicuray ganon. So courts may expunge improper language from the records. So you already know what are those improper language, no? Nagmumura, ganyan, or cursing. So, kung may mga ganon during trial or hearing, of course, it is expunged from the records. We also have the case of Campos versus Campos. It's a 2014 case. So, unbecoming conduct applies to a broader range of transgressions of rules not only of social behavior, but of ethical practice or logical procedure or prescribed method. So in this case, although Alistair and Charmaine were not entirely faultless, a higher level of decorum and restraint was then expected from Eliseo, whose conduct failed to show due respect for the court and lend credit to the nobility of the practitioners of the legal profession. So Attorney Campos violated Rule 7.3, Canon 7 of the CPR. We have the case of Ricafort versus Medina, 2016 case. The issue is whether or not Medina should be held administratively liable. The Supreme Court held yes, there is sufficient proof to establish that the respondent slapped the complainant. So, sinampal niya. Okay? So, contrary to the respondent's claim that it shows that the political motive behind this case is the letter reinforced complainant's credibility and motive. So, the presence of 19 mayors' signatures only reinforced the appealing nature of the respondent's act. It reflects the public's reaction to the respondent's display of arrogance. You have the case of Frey Attorney Untian Jr., 2019 case. The issue is whether or not Untian is guilty of sexual harassment. The Supreme Court held yes. RA number 7877 does not require that the victim had accrued or acceded to the sexual desires of the abuser. Further, it is not necessary that a demand or request for sexual favor is articulated in a categorical manner, as it may be discerned from the acts of the offender. What the law aims to punish is the undue exercise of power and authority manifested through sexually charged conduct or one filled with sexual undertones. You have the case of Parch versus Vitorillo. It's a 2022 case. So, Attorney Vitorillo is suspended for 3 years from the practice of law because the court finds that Attorney Vitorino is guilty of deceitful conduct prescribed by Canon 1, Rule 1.1 of the CPR. So in the contract to sell that he himself submitted before the court, he expressly named himself as the seller and absolute owner of the subject property. What he had was at best an inchoate right, anchored on mere hope that the subject property shall someday be transferred to his name. So this expectancy was admittedly conditioned on the issuance of a final court ruling cancelling the title over the main lot in favor of his clients, who were the ones directly claiming ownership over the subject property in their own right. So he fed false assurances that the trial court would grant his cause. So he even openly blamed the trial court's supposed delay in resolving the pending ownership dispute. And in so doing, Attorney Vitorino demeaned the integrity of the legal processes and tarnished the image of impartiality of the courts that he had professionally vowed to espouse, per Canon 7, Rule 7.03 of the CPR. So the prohibition against foreign ownership of the Philippines' private lands is too basic as a rule for even non-attorneys to be unaware of. So as a lawyer, Attorney Vitorino is presumed to know this. So he is deemed to have acted in contravention of Canon 1, Rule 1.02, or CPR's prescription against counseling activities aimed at defiance of the law. Okay. We have another case, Andaya versus Tumanda. So, Attorney Tumanda violated Canon 1, Rule 1.1, and Canon 7, Rule 7.03 of the CPR. And citing the case of Ong versus Attorney De Los Santos, explained that a lawyer who issues a worthless check is in breach of his oath to obey the laws. Issuing a worthless check is a violation of BP 22, for which he may be disciplined under Rule 138, Section 27. So a penalty of 1 year suspension from the practice of law is usually imposed upon a lawyer who issues a worthless check. However, due to the attendant circumstances, the penalty imposed should be increased to 3 years. So here in this case, aside from issuing a worthless check, again, it's Andaya versus Tumanda. We just cited Ong versus Attorney De Los Santos. So here in this case, aside from issuing a worthless check, respondent has acted in utmost bad faith when he sold to another person the Mercedes-Benz he previously sold to complainant as full payment for the loan obligation. So moreover, his deliberate failure to settle his obligation despite repeated demands is in itself a gross misconduct for which he may be sanctioned with 1 year suspension from the practice of law. Okay. So also, respondent has been using several addresses to avoid being traced and to evade his obligation to complainant. He even refused to answer the accusations against him and to appear in the mandatory conferences despite due notice, thereby causing undue delay in the resolution of the instant case. And we have another case, Malaved versus De La Peña. It's a 2016 case. The issue is whether or not respondent is guilty of dishonesty and grave misconduct. Supreme Court ruled that he is guilty of gross misconduct by using improper language in his pleadings. Respondent violated Rule 8.01 of Canon 8 of the CPR. Now, there's the case of law firm of Chavez Miranda Asioche versus Lazaro. It's a 2016 case. At in disciplinary proceedings against lawyers, only the lawyer who is the subject of the case is indispensable. No other party, not even a complainant, is needed. So the court finds respondents guilty of violating Canon 8 and 10 of the CPR. Respondents twice accused complainant of antedating a petition it had filed with the DOJ without any proof whatsoever. So this allegation of impropriety undoubtedly brought the complainant and its lawyers into disrepute. The accusation also tended to mislead the courts, as it was made without hesitation, notwithstanding the absence of any evidentiary support, and the court cannot condone this. We have the case of Belo Henares versus Guevara. It's a 2016 case. The issue is whether or not the respondent should be held administratively liable based on the allegations of the verified complaint. Supreme Court held yes. The complainant is a public figure and or a celebrity and therefore a public personage who is exposed to criticism. does not justify respondents' disrespectful language. It is the cardinal condition of all criticism that it shall be bona fide and shall not spill over the walls of decency and propriety. So Attorney Guevara is found guilty of violation of Rule 7.03, 8.01, and 19.01 of the CPR and is thus suspended, okay, suspended from the practice of law for a period of 1 year. So let's take note though, if we're lawyers, we should avoid profane language, no, or any language which will make us be held liable for gross misconduct. We have the case of Feni Naya, DF Washington versus Dicen. So Attorney Dicen referred to a complainant, again it's a 2018 case. So Attorney Dicen referred to complainant as a lunatic who was on a crazy quest for revenge against him. So Attorney Dicen violated Rule 8.1, Canon 8 of the CPR for his use of language that not only maligned complainant's character but also imputed a crime against her, that she was committing adultery against her husband. Ayun, so siniraan niya, no? Okay, so we have the case of Canete versus Puti. It's a 2019 case. So Attorney Puti called Attorney Tan bakla in a condescending manner. And to be sure, the term bakla or gay itself is not derogatory. However, when bakla is used in a pejorative and depreciating manner, then it becomes derogatory. Attorney Puti also nonchalantly accused the prosecutors of having been bribed or otherwise acting for a valuable consideration with his remark. Sabi niya, bakit dalawa kayong prosecutor? Malaki sigurong bayad sa inyo. So, Attorney Puti violated Rule 8.01 of the CPR. Let's talk about use of dignified, gender fair, and child and culturally sensitive language. It's in section 4. So example, we have the case of Judge Tumlao versus Camacho. The issues that are threatening court officers and disrespecting court processes. So a lawyer must not disrespect the officers of the court. A lawyer who disrespects the court and its officers violates Canon 11 and Rule 11.03. Again, in the case of Puti, Canete versus Puti, the issue is whether or not Attorney Puti is guilty of provoking and insulting the prosecutors and disrespecting the court. So again, di ba? Oo. So yes, Attorney Puti stated in the open court that the judge was abusing his discretion. So ito yung other part of the story and implied that the judge was partial and biased. So he also threatened the judge that he would otherwise withdraw from the case and walk out if his request was not granted. Sobrang arrogante. So again, such as statements were improper. So Attorney Puti violated Rule 11.03 and 11.04 of the CPR. And such transgression, however, is not a grievous character as to merit his suspension, since his misconduct is considered as simple rather than grave. In Quilendrino versus Icasiano, a lawyer was reprimanded for violating Canon 8, Rule 8.1, Canon 11, and Rule 11.03 of the CPR. Then let's talk about duty to correct false or inaccurate statements and information made in relation to an application for admission to the bar. We have false representations or statements, and we have the duty to correct. So a lawyer shall not make false representations or statements. A lawyer shall be liable for any material damage caused by such false representations or statements. A lawyer shall not, in demand letters or other similar correspondence, make false representations or statements or impute civil, criminal, or administrative liability without factual or legal basis. And a lawyer shall correct false or inaccurate statements and information made in relation to an application for admission to the bar, any pleading, or any other document required by or submitted to the court, tribunal, or agency as soon as its falsity or inaccuracy is discovered or made known to him or her. We also have the duty to report dishonest, deceitful, or misleading conduct. The duty to report dishonest, deceitful, or misleading conduct is that a lawyer shall immediately inform a court, tribunal, or other government agency of any dishonest, deceitful, or misleading conduct related to a matter being handled by said lawyer before such court, tribunal, or other government agency. And a lawyer shall also report to the appropriate authority any transaction or unlawful activity that is required to be reported under relevant laws, including the submission of covered and suspicious transactions under regulatory laws, such as those concerning anti-money laundering. And when disclosing or reporting the foregoing information to the appropriate court, tribunal, or other government agency, the lawyer shall not be deemed to have violated the lawyer's duty of confidentiality. So any such information shall be treated with strict confidentiality. A baseless report shall be subject to civil, criminal, or administrative action. A lawyer is also have the duty to disclose relationship or connection. So a lawyer shall at the first available opportunity formally disclose on record the lawyer's relationship or connection with the presiding officer of any court, tribunal, or other government agency, or any of its personnel, or the lawyer's partners, associates, or clients, that may serve as a ground for mandatory inhibition in any pending proceeding before such court, tribunal, or other government agency. Also have the duty not to mislead the court, tribunal, or other government agency on the existence or content of any document, argument, evidence, law, or other legal authority, or pass off as one's own the ideas or words of another. It's in section 8. So, it's a prohibition against misleading the court, okay, or tribunal or other government agency. So, a lawyer shall not misquote, misrepresent, or mislead the court as to the existence of the contents of any document, argument, evidence, law, or other legal authority, or pass off as one's own the ideas or words of another, or assert as a fact that which has not been proven. So we also have the duty not to solicit or advertise one's legal service. It's in section 17. So the practice of law is a profession, not a money-making trade, and it is a branch of the administration of justice. So the following characteristics distinguish the legal profession from business: that the duty of public service, of which the emolument is a byproduct and in which one may attain the highest eminence without making much money. Number two is that relation as an officer of the court to the administration of justice involving thorough sincerity, integrity, and reliability. It's a relation also to the clients in the highest degree of fiduciary. And lastly, it's a relation to colleagues at the bar characterized by candor, fairness, and a willingness to resort to current business methods of advertising and enroachment on their practice or dealing directly with their clients. So it is highly unethical for an attorney to advertise his talents and skills as a merchant. The most worthy and effective advertisement possible is the establishment of a well-merited reputation for professional capacity and fidelity to trust. So when is solicitation of legal business permissible? So the solicitation must be compatible with the dignity of the profession, made in a modest and decorous manner. So the use of the following are permissible. Number one, simple signs stating the name or names of lawyers. Number two, professional cards bearing the name of the lawyer, office, and residence address, and special lines in law. Number three is advertisements in legal periodicals bearing the same data. Number four, calling cards with a formal picture of the lawyer. Number five, publication in reputable law lists of brief biographical and informative data. And we also have the modest announcements in newspapers, periodicals, or magazines about the opening of a law office or firm, stating the names of the lawyers and the addresses of the firm. Also, we have the legal aid program as a public service. Lawyers also have the duty not to seek publicity. So, as a lawyer, shall not pay or give anything of value to the representatives of mass media in an anticipation of or in return for publicity to attract legal business. We have the case of Kim Teng et al. Versus Young, 2015 case. So, a disbarred lawyer's name cannot be a part of a firm's name. A lawyer who appears under a firm name that contains a disbarred lawyer's name commits indirect contempt of court. Okay? Also have a case of Palencia versus Linsangan, 2018 case. Since a claim for attorney's fees may be asserted either in the very action in which the services of a lawyer had been rendered, or in a separate action, respondents, instead of forcibly deducting their share, should have moved for the judicial determination and collection of their attorney's fees. So a lawyer shall not directly or indirectly advertise legal services on any platform or media except with the use of dignified, verifiable, and factual information, including biographical data, contact details, fields of practice, services offered, and the like, so as to allow a potential client to make an informed choice. In no case shall the permissible advertisement be self-laudatory. The lawyer shall also have the duty not to use any forum or medium to comment or publicize opinion pertaining to pending proceeding. It's the sub judice rule under section 19. So, sub judice rule, a lawyer shall not use any forum or medium to comment or publicize opinion pertaining to a pending proceeding before any court, tribunal, or government agency that may cause a prejudgment or sway public perception so as to impede, obstruct, or influence the decision of such court, tribunal, or other government agency, or which tends to tarnish the court's or tribunal's integrity, or it imputes improper motives against any of its members. And lastly, it creates a widespread perception of guilt or innocence before a final decision. A lawyer should also have the duty not to give gifts and donations to any court, tribunal, or other government agency. In Section 21, prohibition against gift giving and donations. A lawyer shall not directly or indirectly give gifts, donations, contributions of any value or sort, or on any occasion to any court, tribunal, or government agency, or any of its officers and personnel. We also have the duty not to institute multiple cases or forum shopping. In section 22 or 23 rather, sorry, there is forum shopping when, as a result of an adverse opinion in one forum, a party seeks a favorable opinion in another, or when he institutes two or more actions grounded on the same cause on the gamble that one or that the other court would make a favorable disposition. The effect: dismissal of all actions pending without prejudice to the taking of appropriate actions against the counsel or party concerned. Forum shopping is unapplicable to disbarment proceedings, and the certification against forum shopping should be signed by the petitioner and not the counsel. So again, the elements of forum shopping are: number one, two or more cases are pending; number two, involving the same parties, causes of action, and reliefs prayed for. Again, two or more cases must be pending and involves the same parties, causes of action, and reliefs prayed for. So, dapat pare-pareho lang yung mga parties in the case and kung ano ba yung causes of action. For example, money claims, diba? And reliefs prayed for, of course, to acquire the debt from the debtor, ganun. So, yun yung mga dapat similar for an element of forum shopping to occur. So, if one case has already been litigated before and is refiled thereafter, the defense would be res judicata and not forum shopping. So, tapos na yung case, of course, hindi na siya lis pendent siya. Ano na siya? Res judicata. So, a lawyer shall not institute or advise the client to institute multiple cases to gain leverage in a case, to harass a party, to delay proceedings, or to increase the cost of litigation. We also have the case of Go versus Terwell 2020 case, that the essence of forum shopping is the filing of multiple suits involving the same parties for the same cause of action, either simultaneously or successively, for the purpose of obtaining a favorable judgment. An important factor in determining its existence is the vexation caused to the courts and the parties litigants by the filing of the similar cases to claim substantially the same reliefs. In here, Attorney Terwell willfully committed forum shopping when he instituted two actions grounded on the same cause, even if strictly speaking he was not included as a complainant in Father Reyes' uh, complaint. Okay, the outcome in one case would necessarily have an effect on the other, since both cases have the same or share the same cause of action and involve the same parties. So it is not strictly the actual docketing of the administrative complaints, but the mere act of filing multiple complaints with the same causes of action or cause of action and relief, which constitutes a violation of the rules against forum shopping. And there was no showing that Attorney Teruel or Father Reyes informed the IBP Commissioner of the filing and pendency of the subsequent, although undocketed, counter-complaint of the respondent as required under Section 5, Rule 7. Okay, we also have the case of Villanueva versus Alentahan. It's a 2020 case. Here, Attorney Alentahan committed forum shopping when he filed the second case despite the finality of the judgment in the first case. So there's res judicata because there's an identity of the parties exists in both cases. The evidence necessary to prove the claim in the second case had already been presented in the previous case, and the relief sought by the heirs of Bienvenido in both cases were the same, such that a ruling in one case would have resulted in the resolution of the other, and vice versa. The reliefs prayed for, the facts upon which both are based, and the parties are substantially similar in the two cases. So, since the elements of res judicata are present, Attorney Alentahan committed forum shopping. In engaging in forum shopping, Attorney Alentahan committed a violation of Canon 1 of the CPR. Rule 10.3, Canon 10 of the CPR mandates lawyers to observe rules of procedure and not to misuse them to defeat the ends of justice. The filing of multiple cases constitutes abuse of the court's processes and improper conduct that tends to impede, obstruct, and degrade the administration of justice. The filing of another action concerning the same subject matter likewise runs contrary to Canon 1 and Rules 12.02 and 12.04 of Canon 12 of the CPR. A lawyer has the duty not to encroach or interfere in another lawyer's engagement in Section 24. Okay, this includes a lawyer's attempt to communicate, negotiate, or deal with a person represented by another lawyer on any matter, whether pending or not in any court, tribunal, body, or agency, except when initiated by the client or with the knowledge of the original lawyer. So, however, it is the right of any lawyer without fear or favor to give proper advice and assistance to those seeking relief against unfaithful or neglectful counsel. Ito, it's added already in the CPRA, the responsible use of social media. So, a lawyer shall uphold the dignity of the legal profession in all social media interactions in a manner that enhances the people's confidence in the legal system as well as promote its responsible use. For online posts, a lawyer shall ensure that his or her online post, whether made in a public or restricted privacy setting, still holds an audience, uphold the dignity of the legal profession, and shield it from disrepute, as well as maintain respect for the law. Number two is the non-posting of false or unverified statements and disinformation. A lawyer shall not knowingly or maliciously post, share, upload, or otherwise disseminate false or unverified statements, claims, or commit any other act of disinformation. Also, the prohibition against fraudulent accounts. A lawyer shall not create, maintain, or operate accounts in social media to hide his or her identity for the purposes of circumventing the law or the provisions of the CPRA. Lastly, the duty to safeguard client confidences in social media. So, as a lawyer who uses social media account to communicate with any other person in relation to client confidences and information, shall exert efforts to prevent the inadvertent or unauthorized disclosure or use of or unauthorized access to such an account. So that's it. In the next video, we'll talk about Canon 3. The topic is about fidelity.